agreed to assist us in presenting essentially a follow-up to the Bankruptcy 101 webinar that we did, I believe, about 2 months ago, that Mark Wattenberg was able to help us get started. And John is with NCLC. He was mentioned several times on throughout Mark's presentation, and so he has graciously agreed to follow up essentially where Mark left off. So with that, John, I will monitor the questions as you can as well, and feel free to get started. Thank you.
Thanks, Becky, and thanks for inviting me to do this webinar. It will be, hopefully, there won't be too much repetition with what Mark has already covered. To the extent that there is some repetition, it may not really be all that bad thing because particularly for those of you, if you're not a bankruptcy practitioner, these concepts sometimes take a while really to sink in, and so there may be even some benefit to a little bit of that. But I'm expecting that you have that foundation already, so I won't, for example, be talking about some of the distinctions between Chapter 7 and Chapter 13 in terms of how they operate, but more just how it relates to the focus of what I'm going to cover today. And so the focus that I'll be working on is really two things. One is sort of mortgage modifications using bankruptcy law, or how mortgages are affected by bankruptcy in a bankruptcy case. And also the second focus will be on mortgage modifications using non-bankruptcy modification programs like HAMP, but while a consumer is either in bankruptcy or has filed bankruptcy or is considering bankruptcy. So that's really what I'm going to focus on. The first thing that I think is helping, and this may be something you already covered a little bit, but just to be so that we're all on the same page, is that there are really four ways, primary ways, that a consumer deals with a secured claim in a Chapter 13 bankruptcy. One, and probably the most common, is for the consumer to propose a plan in a Chapter 13 where they're going to cure a mortgage default. So they're going to get time in the bankruptcy, usually 3 to 5 years, to spread out an arrearage, the amount that they're in default over that period of time and repay it, and ideally complete the plan, come out of bankruptcy, and their mortgage is fully current. The other is that for some liens, particularly like things like judicial liens, the consumer would be using a provision of the bankruptcy code that allows for that lien to be avoided under certain circumstances. So that's using the bankruptcy code avoidance provisions to deal with a lien. Another would be to, and we'll talk about this in a moment, is to use bankruptcy provisions that allow a secured claim to be modified and to be paid at the value that's based on using the formula that's in the bankruptcy code, and to pay that over the plan term. And then finally, the consumer can just decide to do nothing. Now that may not benefit the consumer, but usually that would be in a case where the consumer is filing a Chapter 13 to deal with some other problem. Maybe it's a car loan and again, I'm talking about mostly mortgage cases here, but there may be other reasons why the consumer may be dealing with a domestic support obligation or something like that. So in terms of the bankruptcy discharge itself, how does that affect a mortgage? So if the consumer gets through a Chapter 7 and they complete that and they get a discharge, so at the end of the case they're discharged of their debts, what that means is that their personal liability on the debts is discharged. It does not, however, affect any mortgages or liens on the property or secured debt unless there was something that happened during the bankruptcy case that either voided it or eliminated it. Otherwise, we as bankruptcy practitioners sometimes refer to it, the lien passes through the bankruptcy unaffected. And but the debtor's personal liability has been discharged. The creditor could not come after the debtor personally They might be able to foreclose on the property, but they could not get a judgment against the debtor or come after the consumer or debtor personally, unless there's been a reaffirmation agreement that the consumer signs, and we'll talk a little bit about that in just a second. In Chapter 13, it's the same thing, except that if the consumer is doing what I mentioned earlier, they're curing a default, and they're treating the mortgage under this particular section of the Bankruptcy Code, it's Section 1322B5, which allows for the cure of defaults and maintenance of regular ongoing mortgage payments. If their plan provides for that, then the mortgage is not discharged. Even their personal liability on the mortgage is not discharged. Okay, so how do you deal with mortgages or just secured claims in general? And this is a fundamental concept in bankruptcy. It's sometimes, we refer to it as a cram down or a strip down, and sometimes we talk about strip offs, which is a little bit different. But whenever we mention those terms, what we're really talking about is using this section of the Bankruptcy Code, which is the key provision in the code that deals with secured claims. And it's stripped to its basics. What it really says is that if you are a mortgage holder, you're a secured creditor in a bankruptcy, basically your lien is only as good as the value to support it. So you only have an allowed secured claim in bankruptcy that it's capped, basically. The amount of it is capped at the value of the collateral. And what this means is that the claim can be bifurcated in the sense that a creditor outside of bankruptcy has a fully secured lien, but in bankruptcy they may only have a partially secured lien. And I'll show there's some illustrations that make this a lot clearer to you if you're still struggling with that. But what the 506D also, another section within 506 says that to the extent that the amount of the creditor's claim is not an allowed secured claim, it's voided. However, and so you might think, well, in Chapter 7, that's great. I could file a Chapter 7 if the house is worth only $50,000 and I owe $75,000, and I can just void that $25,000. That's sort of an unsecured part of it. Well, you don't get to do that in a Chapter 7 because of a Supreme Court decision, the Dusnep cases, that said that basically that kind of strip down and avoidance of the lien under 506D cannot happen in a Chapter 7. But and so that's why we focus more on the provisions, the application of that Section 506 in Chapter 13. So this is the main provision of the Bankruptcy Code in Chapter 13 that deals with secured claims. It relates to that 506 that I just mentioned, and the general default rule is that a consumer can propose a plan in Chapter 13 where they have the right to modify the rights of the holders of a secured claim. Of course, what Congress gives, they take away in the next clause, which is that other than a claim secured only by a security interest in real property, that is the debtor's principal residence. So this is often referred to as the anti-modification provision within this general section that allows you to modify secured claims. And over the years, there's been just basically every word in that other than clause has been construed, and construed narrowly, fortunately, so that there are a number of exceptions. I'm going to go through one of them in more detail, and I know you covered this a little bit in the last presentation, but I'll go over that again. I'm not going to spend as much time with the other exceptions because they are, to some extent, less helpful. But the first one is, and it's really emphasizing the language in that anti-modification clause that that says claim secured. So it has to be a claim secured. What is that? Why is the emphasis on that? Because if if the claim isn't at least partially secured by the mortgage, by the value of the property, then it can be treated effectively as a wholly unsecured mortgage. So here's the illustration that will help you to hopefully understand this. If you have a house that's worth $120,000, and the first mortgage on the property, the balance of it is $125,000, and there's a second mortgage that has a $15,000 more balance, the total amount of the debt is $140,000. And you can see in relation to the value of the home that this is an underwater property. And here you can see the illustration again. You can see that the first mortgage is undersecured by $5,000, and that second mortgage is completely unsecured in the sense, again, think of that 506 analysis, 506A analysis. The creditor only has a lien up to the amount of the value of the property, and here that second mortgage holder has there's no value to support that lien. It's completely unsecured. So what can we do in Chapter 13 with that second mortgage that's completely unsecured? The courts have held, although this has not been something that's been decided by the Supreme Court as yet, but every circuit has said you can do this, and the Second Circuit, where you're located, says you can do this. And the way you get to do this, to strip off these, and that's the term we use when we talk about a wholly unsecured mortgage, the way you strip it off in a Chapter 13 is this, and the way that we get to that point was from this earlier Supreme Court case, the Nobleman case, which dealt with a partially secured lien. So in that example I just gave you, the first mortgage was partially secured. It wasn't completely secured. There was a little bit of it that was underwater. And what the Nobleman's case said was you cannot modify that mortgage. You can't really, the anti-modification provision would apply. And just because it's partially secured doesn't mean you get to use that 506 and strip it down. Again, that's the term we use for partially secured. But what the Supreme Court said in that case, which is very helpful to this analysis, is it said that before we can decide whether the lender even gets this protection from the anti-modification provision, what you need to first decide is you need to look at 506 and to see whether they're even the holder of a secured claim. That's the essential argument. And here in this example I gave you, that second mortgage holder, as we saw by the illustration, is completely unsecured. So they are not even the holder of a secured claim in the bankruptcy context, in the way we look at it in bankruptcy because of the way 506 operates. So they're not the holder of a secured claim, and so as a result of that, all the circuit courts, including the Second Circuit, have held that you could strip off that wholly unsecured second mortgage. And what does that mean? You know, it typically applies to second or third, basically junior mortgages. The way you look at it is that if it is wholly unsecured, then at the end of the case, if the debt consumer completes their Chapter 13, they will be able to have an order from the court saying that that lien has been fully satisfied or released. It's not that you're using one of the necessarily the lien avoidance provisions. You're just treating that debt for what it really is, an unsecured debt. So what it would be, it might be paid something. So in this case, where we have a $23,500, if the debtor's consumer's plan is paying that all the general unsecured debts in the plan at 5% or 10%, let's say, then that creditor will get something. They'll get treated as an unsecured creditor, and they'll get 10% or $2,300.50. They'll get 10% paid, and all the rest of it will be discharged, and the consumer can ask for an order that allows the lien to be released or indicated that it's completely satisfied. Okay, so how do you do these calculations? I mean, we've already sort of illustrated this, but one thing that sometimes attorneys who are just, or even housing counselors, you may have this notion that, well, when I figure out whether the property's underwater or whether it's a wholly unsecured, you know, do I factor in the amount that the consumer might have by way of exemption? Well, you don't for this purposes. Mark probably mentioned in the last webinar you had that you do consider exemptions when you're using the judicial lien avoidance provision under Section 522F. That's completely different than what we're talking about here. That is that's only for judicial liens. That's when a creditor goes off and gets a judgment against the debtor and it gets recorded as a lien. Here we're talking about mortgages, voluntary mortgages, and when you're doing this strip-off analysis and you're looking at 506 and whether the creditor has is the holder of a secured claim, all you're comparing the lien that you're trying to strip off with the value of the property and any other senior liens on the property. And it's not just mortgages. I mean, in the example I gave you, it was the first mortgage on the property, but it could be other mortgages on the property. You know, there could be a first and second that's before a third mortgage, but it's also other liens that have priority to the one you're trying to strip off. So it could be a tax lien on the property. In most places, that statutory tax liens do have priority. There could be other things like a silent second on the property or some interest subsidy recapture if it's a rural housing mortgage on the first. So all those get considered. Okay, what about other types of modifications? Now here, what I am going to be talking about really briefly, because the reason why I'm not going to spend as much time with this and the reason why these aren't as helpful to consumers, they can be, but these are other ways where you can argue that the anti-modification provision doesn't apply and you're allowed to modify the mortgage. The problem with this is that if you, let's say you have a $100,000 mortgage and the property's worth $75,000. Well, that's great. If you can find a reason why the anti-modification provision doesn't apply, what that means is you get to treat that mortgage as a $75,000 secured claim and a $25,000 unsecured claim. The problem is that unlike where you're stripping it completely off and treating it all as unsecured, now you have to deal with that $75,000 mortgage, the stripped down amount. And under the bankruptcy code, because you're using a different concept here, you're going to need to treat that secured claim and pay it off during the life of the plan. And that may be difficult for, even though you know the consumer would get this benefit of getting $25,000 of the mortgage amount wiped out, they have to pay that $75,000 during the life of the plan. And the longest you can go on a plan in bankruptcy is 5 years in a Chapter 13 plan. And for a lot of consumers, paying $75,000 off, particularly low-income consumers, paying $75,000 off in the life of a 5-year plan would be difficult. Now, if you have a consumer with a low balance mortgage, that may be possible, and it works really well with mobile homes because they decrease in value so much that that's where it's most helpful. So, as I said, I'm going to go through these quickly because of that that problem that they're not always so helpful. One focuses on the word only. So if there's any additional security for the mortgage, and some of this has changed since 2005. It's a little bit more difficult to make these arguments. But if the mortgage is secured by other things, and this is often true with credit unions where they take blanket security interests and cross-collateral, where there's cross-collateralization, where they might have a loan not only on the house but also on the cars and whatever. that's a situation where you can argue that there's additional security. It's not secured only by the debtor's, the consumer's home, and therefore the anti-modification provision doesn't apply. The lender doesn't get the benefit of this provision that says you can't modify if it's a home secured loan. Another one is when we look at this language closely, and actually there's a Second Circuit case that's directly on point on this, that focused on the words "that is." Imagine this whole statute, and those two words were given a lot of meaning by the Second Circuit, and said, look, if it's not real property that is the debtor's principal residence, and what they focused on here was if it was a multifamily building. So if there are other units in the mortgaged property that is not the debtor's principal residence. So here the debtor might live in the first floor of the property, but rents out the second and third floor. And what the Second Circuit and other courts have said is that property is not just the debtor's residence, debtor's principal residence. It's a residence for other individuals as well, and so the anti-modification provision doesn't apply. Another one is the two words "real property" in this phrase. So if the property is not real property, then this doesn't apply. And so this could happen if you have a mobile home, and under state law it's treated as personal property rather than real property. Then you could strip it down. And again, this is really helpful because the consumer might, the mobile home might only be worth $15,000. And so even though they owe $50,000, well, the consumer would only need to pay that $15,000 as the secured claim in the Chapter 13, and even low-income consumers would be able to pay that off in 5 years. So that's why that can be very helpful. Finally, the last one that I'm going to talk about in terms of anti-modification is this section that's Section 1322C. This was added to the Bankruptcy Code in 1994, and it deals with any sort of short-term, a balloon payment mortgage. We don't see these as much anymore, but there's still some of them out there where the mortgage would come due during the life of the plan. And this has recently even been applied to, some courts have said it's not even so much whether, certainly if the last payment comes due during the plan, this provision applies and it allows you to modify the mortgage. But a lot of courts have said that even if there's been an acceleration under the terms of the mortgage, not so much because of a default, but under the terms of the mortgage, other than a payment default, that could also trigger this exception. And there's a very recent case that talked about it in terms of a reverse mortgage. It was a family member, an heir, who was trying to deal with the mortgage, and the lender was calling the whole note due, and the court said that this provision applied, and the consumer could, who is the heir, could modify the mortgage, the reverse mortgage, by making payments into Chapter 13. So are there some benefits outside of these provisions, or why would a consumer file a Chapter 13 if they can't modify? Well, there are some other benefits. One is that there is the automatic stay, and I know Mark talked about this last time, that would protect the homeowners. There are exceptions to the automatic stay, but the general rule is that while the consumer is in the bankruptcy, whether it's a 7 or a 13, the mortgage lender, generally can't foreclose. They can ask for permission to foreclose, but they can't do it without getting that permission. The other one, of course, I talked a little bit about this, is that you can, and it's a very powerful, remedy that the consumer has, which is to be able to file a plan where they can, de-accelerate any acceleration of the mortgage by the lender and cure a default. There's judicial liens that can be dealt with by avoiding those if they impair the consumer's exemption in the property. There's the possibility of bringing claims in the bankruptcy case, predatory lending claims. In some, depending upon what your courts are like locally, it may be a good place to litigate some of these claims. And there are some special provisions that deal with transfers, pre-petition transfers for less than, of real value, and those can be helpful with foreclosure rescue scams. But I'm not going to have time today to go through that, but it's just something to be aware is available out there. A little bit more detail on the secure and maintain provision. It is in that section 1322b5, the mortgage arrearage, and that would include, so the consumer would need to pay off during this plan all of the pre-petition arrearage, and that would include any attorney's fees or foreclosure costs that were incurred, but the court can decide whether or not those fees are reasonable or not, and so that's another way in which the bankruptcy court can be helpful, particularly if there are excessive fees or unauthorized fees. The court can decide that they're not required to be paid. And the bankruptcy rules now have new requirements that there needs to be an itemization of all of those pre-petition fees, and there needs to be a form that's filled out, an official form, where the lender describes all of those fees. The consumer needs to provide, this only works if the consumer can make payments both on the arrearage, and they have to be able to maintain their regular ongoing payments while the case is pending. So there has to be that sort of feasibility analysis that to figure out whether that is affordable for the homeowner. That's pretty much it on that. So what I'd like to switch to now, in fact, I'm just wondering, I'm hearing a little sound on my end. I don't know if others are hearing that, but we'll keep moving on. So. Okay, what I'm going to focus on now are how consumer would fare if they're either trying to get a mortgage modification through HAMP or some other program, and they're thinking about bankruptcy, or they already filed bankruptcy, or not. So I'm going to go through the basic rules that apply in terms of the guidelines, and I'm going to preface this by saying I'm going to focus on what all the guidelines are on this. And please, just like anything else in the world of mortgage modifications, there's not always good enforcement of these, and sometimes you're going to have services who are going to ignore these. But it's important as advocates for us to know what are the rules and to make sure that we're forceful in reminding the servicers that they ought to be following the guidelines, and ultimately, may need to bring some litigation to try to get them enforced. But some of the advantages of using these modification programs while the consumer is in bankruptcy is that they do have a way of, you have the advantage of trying to combine some of those bankruptcy remedies we talked about and the mortgage modification programs themselves. So one of the real advantages, of course, is having the automatic stay to protect the homeowner while the homeowner is being considered for a mortgage modification. There is a way, the other advantage is that the consumer can deal with their other debt. And so you can think of it as potentially as a way for there to be sort of, one-stop shopping for the consumer. They not only work on getting a mortgage modification, but they can also deal with all that other debt that they might have, which can actually have an effect on even their eligibility for the mortgage modification, because if they're able to discharge and eliminate a lot of that other debt, the credit card debt, it obviously will have an impact on the back-end DTI ratios. And in fact, it would, it potentially will allow the consumer to be more successful in staying on a modification and avoiding redefault if they're not having to deal with this other debt that maybe has been discharged in the bankruptcy case. And finally, when you're dealing with a homeowner that has multiple mortgages on the property, you could be focusing on the modification, a HAMP mod or whatever on the first mortgage, and using the bankruptcy provisions to deal with the second mortgage by stripping that off if it's wholly unsecured, like we just talked about. And that can be helpful for the homeowner in getting sort of a complete, way of dealing with their foreclosure problem. So let's focus on what the HAMP says and the Fannie and Freddie and the GSE HAMPs and FHA say about in particular, at least at first, let's talk about what if the consumer has already filed a bankruptcy. And particularly, this often comes up when they have filed a Chapter 7 bankruptcy and maybe they didn't reaffirm the mortgage. Generally speaking, it's not a good thing for the consumer to reaffirm debts if they're going through Chapter 7. They're giving up their discharge. Normally, particularly with mortgages, it's not something that they would normally want to do unless they absolutely have to. And it's usually advisable for them not to reaffirm. So if they haven't reaffirmed the debt, what does that mean? Servicers, and you've heard this, I'm sure every one of you have heard this if you're familiar with the general areas of bankruptcy, is that servicers will often say, well, if there's not been a reaffirmation, we're not going to consider you for a loan mod, or we won't do it unless you reaffirm the debt. That is general, and while that's often repeated, it goes against what all of the mortgage modification programs say should be the case. And here it's uniform. Both the HAMP guidelines say this, the Fannie and Freddie guidelines, as well as a HUD mortgagee letter, which is on your slide, make it very clear that if you were in a prior Chapter 7 and you were discharged of your personal liability and you didn't reaffirm, you are still eligible for these modification programs. What the servicer is supposed to do is consider you, and if you're eligible, they're supposed to modify the agreement to include language, which I've got on the slide for you here, which basically converts the modification agreement into a non-recourse agreement. It basically says, I was discharged, I'm not personally liable, and I'm not going to be personally liable on this mortgage. The lender still has the right to enforce the mortgage and can foreclose on the property. It's just that the homeowner is not personally liable. Now, again, even with this clear FHA or the mortgagee letter, we've even heard that some of the advisors in the HUD servicing centers will say that, oh, you have to have a reaff. I don't know what to say other than, this is just plain wrong, and you just got to push the servicers as much as you can. I mean, one thing we might have that's helpful, and I'm sure, I don't know if you've had a webinar on this yet or will soon, but there are new regulations that will be going into effect in January of next year. That the CFPB regs under Regulation X that have provisions that deal with loss mitigation. And I think that may provide at least an opportunity if you have a servicer who's not even willing to consider or take an application from a borrower who has had a prior Chapter 7 and doesn't have a discharge. I think that you will at least have potentially some redress to at least get that consumer considered, because I think at least under these new CFPB rules, they should at least take the application, and if they're ultimately going to give this answer that you need a reaff, they'll at least have to be putting that in writing and so forth, and you can access the appeal process through the new CFPB regs. So I'm not saying it's going to be perfect, but at least it's some additional tool that might be available to address this. And the other thing is for you to be familiar with all the provisions I just mentioned, and also to be able to have responses when the servicer says, well, you just need to go back to bankruptcy court and get a reaffirmation agreement entered. You know, reopen the bankruptcy case. I think what you want to be prepared to say that, you know, that really can't be done. You know, the bankruptcy, there are exceptions to this, but basically a reaffirmation agreement has to be entered into before the consumer receives their discharge in that earlier case. Now, there may be some bankruptcy judges who have said that they'll allow a reopening of a bankruptcy case, and they will enter a reaffirmation agreement even after the debtor has received their discharge. But the clear majority view is that there is no authority for the bankruptcy court to do that, to vacate the discharge basically, and to enter in a reaffirmation agreement after the debtor has already had a discharge, and for it to be enforceable. That's the clear majority rule, and I think, you know, that's just something that's got to be said to the servicer, is that you know, this you know, it can't be done. So, and there's been some cases that have focused on this. You know, often this doesn't get litigated, but there have been some servicers, in some cases, which have looked at this and said, look, I'm not going to reopen this. There's a lot of cases that say we're not going to reopen a bankruptcy case just to enter a modification agreement or a reaffirmation agreement because the consumer wants to do this after a discharge. And there's been some recent cases that have said, in addition to the fact that we can't do this under the bankruptcy code, there's no reason to do it because the HAMP guidelines are very clear that you don't have to have a reaffirmation agreement. And so here are a couple of decisions that deal with that issue. All right. Well, what if just to sort of summarize on that, it's still a problem, you know, and we continue to do advocacy on this, that whole issue, and I think, you know, some of the servicers have heard of doing better on this, and others continue to present problems on that. But anyway, that's kind of where we stand. So what about if the borrower is in bankruptcy? Can they be considered for modification? So what we have here is kind of a mixed message that's come out of the HAMP guidelines. On the one hand, there's a provision of the HAMP guidelines that says that a borrower in an active, yes?
John, can we have an issue with, there's somebody on the line, even though we've muted everybody, wondering if somebody has accidentally dialed a different code, which we don't. This is, bear with me as I, go ahead, Michelle.
Somebody on the telephone right now, one of our participants, that's actually, and I can't mute you. So either put your phone on mute or stop breathing into the phone. I don't know what else I can do. I'm sorry for the distraction, John.
That's fine. I think it may have stopped, so thanks for doing that. Okay, so what about borrowers in bankruptcy? And again, I sort of said, HAMP, unfortunately, the Treasury Department was somewhat kind of sent out a mixed message on this, and we worked very hard to get them to emphasize the second part of this. But what the guidelines say is that a borrower in bankruptcy in either Chapter 7 or Chapter 13 is eligible for HAMP at the servicer's discretion. But importantly, they did add in accordance with investor guidelines. So what that means is that it is at the servicer's discretion, but you shouldn't be denied, consumers shouldn't be denied even consideration for a HAMP mod if they're in bankruptcy, if the investor doesn't have anything that, you know, would prohibit that consideration. And in fact, I have really seen investor guidelines that sort of address that. So I think that's one way that we sort of can overcome that at the servicer's discretion. I know a lot of the servicers ignore the fact that it says in accordance with investor guidelines. But probably more importantly, Treasury did at least do what we were hoping they would do, which was to put in that same provision the language that says notwithstanding the foregoing, so notwithstanding the at the servicer's discretion, the borrower must be considered. So it's so that if a request is made by the borrower or the borrower's attorney. So you can't, and that's where you can get at that issue of whether there really is an investor guideline that prohibits it. They have to be considered. If they are in bankruptcy and they say, I want to be considered, the servicer has to take the application. And some servicers initially were, sort of ignoring that. And I think that at least it's been a little better on that. And I've given you the citation for the HAMP handbook that has that. Now, what about Fannie and Freddie? Fannie, unfortunately, with their HAMP, their Fannie HAMP, has included the at discretion language, but did not include the must consider language. Freddie, on the other hand, is actually better than even HAMP in the sense that they don't have the at the discretion of the servicer, and instead it does say that it must be considered if the borrower requests it while the consumer's in bankruptcy. Now, we get to a much better situation when we're talking about a consumer who is on a trial plan and they decide to file bankruptcy. And this will relate to, when we come at the end, we're going to talk a little bit about when this all should be done, before, after, or during bankruptcy. This is helpful in the sense that this is actually a very helpful provision, and there's no ambiguity here. This is very clear, and it's very clear under HAMP and Fannie and Freddie HAMP that if the borrower is currently on a trial plan and they file bankruptcy, the bankruptcy cannot be the basis for denying a permanent modification. As long as the consumer continues to make their TPP payments, the fact that they have filed bankruptcy cannot be used against them for denying a permanent mod. And this provision also talks about how the servicer needs to work with the homeowner to obtain court approval, if bankruptcy court approval of the permanent modification, if the bankruptcy court requires it or wants it. I mean, so it's not mandatory. It's just, if the court requires it, but they have to. The servicer will often want that, and so that is what would need to be done. It also, this provision also talks about how the trial plan can be extended if court approval is needed. There are a couple of other provisions that deal with HAMP in Chapter 13. These can be helpful. What they basically say is that if the consumer's on a trial plan and they're making their payments, the servicer can't try to undermine the bankruptcy case. They can't try to file a stay relief motion or a motion to dismiss the case or object to the plan that the consumer's, the Chapter 13 plan. So that's a very good provision. Fannie has this kind of, Freddie Mac has this kind of strange provision about how the consumer cannot be converted to a permanent mortgage until or unless the mortgage is released from the bankruptcy plan. What that really means is that the consumer is going to have to dismiss the Chapter 13 plan. I don't like that provision, but it is out there. And so what it means is that the consumer may need to, if they may need to dismiss the Chapter 13 if they really want to get this, the permanent modification. There is this provision about getting court approval. Just to be aware, at least in a Chapter 7, it's not so clear that the bankruptcy court even has jurisdiction to approve a modification, and so some judges may resist that. In a Chapter 7, it's usually not as big of a big deal, and in any event, if the court says, look, I don't want to approve this, I don't need to approve it, that doesn't mean the consumer doesn't get the modification. It's more a question of just requesting it, and so forth. So what are some of the other issues that that relate to this bankruptcy and HAMP and so forth? The only things I wanted to talk about are, what if the consumer doesn't have a trial plan yet and they're thinking about filing a bankruptcy and they want to be considered for a plan, for a modification? How do they deal with the plan? I mean, normally the Chapter 13 plan would provide for the consumer to be curing the default and maintaining the regular mortgage payments, but for obviously a lot of consumers who are looking for a HAMP mod, they probably can't afford that. And so could you propose a plan that proposes to pay what the homeowner hopes to get as a modification amount, which would be 31% of their income? And you can try that in some courts and are willing to go along with that, and the view would be that either the plan would be confirmed at that amount, subject to reconsideration if the debtor doesn't get a permanent mod, or that the confirmation hearing could be on the Chapter 13 plan could be continued until you get a decision about whether the consumer is approved for a mod. And there's at least one case site I give you where the court found that's fine to propose that, and that would provide protection to the lender at least until the plan can be confirmed. If you are in a situation where the court is sort of deferring or delaying confirmation until there's been an ultimate decision on the modification, the important thing is to keep the court informed about where that is. Usually the court will schedule that for status conferences. In the Southern District in New York and the Eastern Division, also there is a formal loss mitigation program, so it's a lot easier there to deal with all of these issues. But where there isn't a formal loss mitigation program, you have to try to do this in a more informal basis. Another important thing about the Chapter 13 is that whatever gets put in a final confirmation order does have a res judicata or a binding effect, and it can be helpful, in particularly if a servicer is saying that they didn't agree to a modification. And in fact, I've given you some other cases, which you'll see in the slides in a moment, on that issue. So one of the things that, now that we're in this period where HAMP's been around for a while and a lot of other modification programs, one thing I sort of added to my discussion on this, on bankruptcy, particularly for non-bankruptcy practitioners, is to know that bankruptcy, that whole cure and default provisions, those can be used to help a homeowner who might have fallen behind on a modification. Hopefully homeowners who get good mods will stay on them and not default or redefault. But if they do get in that situation, it's important to remember that that cure provision could be helpful to a homeowner. And so, when you're on I've seen no cases on this yet, but I think there's some good arguments that can be made because of the way the right to do this is so broadly defined under the Bankruptcy Code. But I think if the consumer is on a TPP and they are in default on a TPP, at least under HAMP, if you're more than 30 days, all payments have been made no later than 30 days after the final. Actually, I think that default provision is now has been changed. But whatever the exact default trigger is, the consumer ought to be able to file a Chapter 13 and try to be able to cure that default and to stay on the TPP. And again, I haven't seen cases on this, but I do think that that right exists, and it's something to keep in mind. Timing may be important to try to do that before some formal action has been taken. The other thing is that once the consumer has a permanent mod, well, a permanent mod is a permanent mod, and so certainly there's no question about the fact that the consumer could use a Chapter 13 to cure a default on that permanent mod. There might be an issue about, what the consumer loses on a permanent mod is the notion of being in good standing, I think, and what that mainly means is they might lose the benefit of some of the payments that would go, or the servicer might lose some of the enhancement payments or and incentive payments, as well as the consumer. And I think that there's a good argument that the consumer could file a Chapter 13 to cure a default, and that should be, that should effectively reinstate their good standing. So that the incentive payments would apply. And that's primarily because the incentives are coming from the Department of Treasury, and there is a section of the Bankruptcy Code, Section 525A, that says that governmental units cannot discriminate against a consumer just because they have filed bankruptcy. So again, I think there's some good arguments there. I'm not going to go through these cases. We're almost coming close to the end of the hour, so I'm not going to go through these cases. I just want you to see that they're out there. This one in particular deals with the issue more in Chapter 7, where the consumer can get an extension, basically, of the automatic stay if they are actually considering a reaffirmation. And this might be one of the few reasons why I would say a consumer might want to agree to a reaffirmation agreement in order to keep that automatic stay in place while they're waiting for a decision on whether they're going to get a modification. These are some cases that are helpful on the issue of whether or not, if the consumer, if the servicer, for example, hasn't signed the agreement, the mod agreement, the borrower has and the servicer hasn't, and they're trying to back away or renege from the agreement. These cases have been quite helpful in saying, look, by your action, servicer, you're bound. And so that's where bankruptcy, the supervision of the bankruptcy, can be helpful. So I'm just going to quickly go through this and try to answer a question. I'm also going to be available to try to answer some of your questions after the webinar, and we'll figure out a way to get those answers to you in writing. So hopefully we'll be able to do that if I haven't answered them during the seminar. So what I'd like to just very quickly, and this is kind of a complicated thing, but this whole question about, if you are going to try to get a modification or thinking about it or have one, when is the time to do it if you're considering bankruptcy? And so there's some issues about whether you would get whether you should try to get the modification before bankruptcy. And I've already mentioned earlier it shouldn't affect your eligibility, although there is that issue about being considered. Well, it won't affect your eligibility for mod based on what we said earlier. If you had already had this modification, and the debtor will remain, the consumer debtor would remain eligible for the permanent mod even if they have a bankruptcy that was filed during the trial plan. Now, there are some questions about, it shouldn't happen. As I said, it should not affect eligibility, but if it's a non-HAMP mod, a proprietary mortgage, I suppose the servicer might say that the filing of the bankruptcy is an event of default under the mod. But again, if it's been, and that's really if it's a temporary trial plan. If it's a permanent mod, again, it's a permanent mod, and it should not affect if the bankruptcy is filed later. One of the things about getting a mod before bankruptcy is it not necessarily going to help in the analysis of that back-end debt-to-income ratio, and it might not help with subordinate liens in terms of getting approval anyway. You could still deal with those liens afterwards. And the other is, just quickly, I'm not a tax expert. I'm going to say that right up front. but you all should know that whenever there's any debt that's discharged in bankruptcy, it is not a taxable event. The bankruptcy code, actually it's federal law outside of the bankruptcy code, in the tax code is very clear that any debt that's discharged in a bankruptcy case is not discharge of indebtedness income, and so it's not a taxable event. So one of the things about, if you have the mod before bankruptcy, you don't necessarily get that benefit of maybe having the discharge in bankruptcy of that, particularly if there was a principal reduction that is part of the modification. Anyway, I'm not going to spend so much time. These are the slides are here, which kind of describe. Probably the best one might be the loan mod during bankruptcy for the reasons that I mentioned already, because the rules are very clear, but that's if the consumer really has a temporary mod. The rules are very clear that they cannot be discriminated against. And I think actually I've covered some of these in the earlier discussions. A mod after bankruptcy is again, it's not going to affect your ability for the eligibility for the mod, except for this issue about whether it was a Chapter 7 and whether a reaffirmation agreement was entered. And I've told you what the rules are. Even though the rules are very clear, it shouldn't be a problem, there still continues to be pushback by servicers on that issue if there's not been a reaffirmation agreement. I think we only have maybe a minute or two. Becky, is there, I'm trying to see if there's one of the questions which
perhaps you could talk about FHA. The first one there, is there any guidance for FHA loans and whether they can be considered for modification when in bankruptcy?
Yeah, so that one that I had given earlier, there is a slide, and I tried to include the FHA for all of this. What you really want to read is the mortgagee letter that deals with this, and it is cited in the earlier on my PowerPoint. There was a mortgagee letter that the FHA came out with a few years ago that is very clear that it's very similar to the HAMP guidelines in the sense that it says, and it's very clear that just because the consumer is in bankruptcy, the servicer shouldn't have to worry about the automatic stay and contacting the borrower. As long as the homeowner wants to be considered, they absolutely should be considered for a loan modification, even though they're in bankruptcy. And it's also very clear that even if they had a prior Chapter 7 discharge, and the didn't reaffirm, they still are eligible and can be considered for any of the FHA loss mitigation provisions. So it's that HUD mortgagee letter 2008-32.
All right, and then I think there's two more questions I hear quite frequently from folks. The first one is, sounds like it's a co-borrower, but the base question is common. The bank is accepting payments, but they refuse to send a monthly bill. Is there something that the homeowner can do? And in this case, what sounds like the person is saying is the co-borrower filed bankruptcy and is not paying on the loan, but the other borrower that did not file bankruptcy is still trying to repay the debt?
Yeah, in either case, okay, so whether it's the co-borrower or the debtor, the good news on this, and whoever asked that question, you're absolutely right, servicers have been, it's all part of this fear that they have of violating the automatic stay, even though there's very clear court decisions that say that just sending monthly statements where you're just providing information, as long as you include a disclaimer or something that says you're not trying to collect the debt, doesn't violate the stay or doesn't violate the discharge injunction, and they should do it. Nevertheless, they are often resistant in doing it, and it has been a problem. The very good news on this, and this will be January of next year, you all will become familiar with this, I'm sure. There's all of these new CFPB rules that are being issued. One of them deals with the requirement of providing periodic monthly statements. And the good news is we pushed very hard with the CFPB on this, and the good news is that they did not include a bankruptcy exception. So if the consumer is in bankruptcy, and whether it's the consumer themselves or a co-debtor, the rules are very clear that there is no bankruptcy exception. They're still supposed to comply with the new CFPB rule. The only thing that the CFPB said is that they can modify the monthly statements to include something like a disclaimer that says, you're in bankruptcy and we're not trying to collect the debt. But all of the information that's required to be disclosed, and there is a substantial amount in these monthly statements, will still need to be provided after January of next year. So I think we finally have maybe a solution to that problem, or at least I hope we do.
Okay, great. And then the other one is, what steps can be taken if the servicer is denying a modification because of that lovely rule of that you didn't reaffirm your debt under the investor guidelines? What's your recommendation as to what can be done?
Well, I think, again, the first part of it is just coming up with the reasons why the service is wrong. And again, I understand this is not an easy task, but I know some attorneys and advocates who've had success with this, is just laying it all out for the servicer. One, the HAMP guidelines say you don't need, or whatever it is, FHA guidelines, whatever program you're dealing with, Freddie, Franny, you just cite the provision and make it very clear no reaffirmation is required. The other thing is you should point out to them a provision, and a lot of the servicers are not familiar with this. I did include it on my slide, but I didn't go over it earlier, which is there was a change made in 2005 to the Bankruptcy Code. It's in Section 524J of the Bankruptcy Code. And what it basically says is that it kind of codified what some circuits had already allowed, which is this notion of a ride-through of a mortgage without reaffirmation, and that it should be business as usual. What the Section 524J says, and it provides comfort really to mortgage services, is that they can continue. It says that the servicer or the mortgage holder can continue to collect payments and receive payments and to service the mortgage in the ordinary course of business without violating the discharge injunction, even if the debtor didn't reaffirm the debt. And in fact, it says that this provision is in lieu of basically enforcing their lien rights. So rather than foreclose and without violating the discharge injunction, they can continue to accept payments. I still talk to servicer attorneys who are unfamiliar with that provision. So again, make them know that that's out there, and maybe that'll provide some comfort. I don't know. The other final thing is, again, as we go into this new regime of the CFPB regs, I think what you need to do is if the servicer just says to you, we won't even, we're not even going to accept an application because the debtor didn't reaffirm, then I think you want to be threatening them. For those of you who are lawyers, be thinking about bringing a court action against them under the CFPB rules. I think that they have an obligation to accept that an application from the borrower, and their failure to do it would be a violation of the new loss mitigation rules. And those loss mitigation rules are all privately enforceable under RESPA. They do have a private right of action, and so it may be just the threat of a court action might get the servicers to start reconsidering their position on that issue as we go forward after January 11 of 2014. Becky, I think that, is there anything else, or did you want to wrap it up at this point?
Well, we do have more questions, so I think we'd like to be respectful of people's time if they would like to stay on, and maybe, John, if you wanted to go through some of these other questions.
Yeah, I could do that, and that would be fine. And if I certainly won't be offended if anyone needs to get off. I understand webinars lasting longer than an hour are hard to sometimes include in your schedule.
Okay, so then why don't we do that then? I can just read the questions that we still have unanswered.
Before everybody leaves, I just want to give people the CLE code verbally. I did put it in the chat feature, but today's CLE code, if you want CLE credit, is S is in Sam, U, Z is in zebra, the number 7, AB. So that's SUZ 7AB. Thanks.
Okay, so like I think actually, let's if a client thinks that a mortgage was stripped or crammed down in a bankruptcy, what evidence would be in the bankruptcy case to confirm the client's suspicions? Would there be an order, and then would the borrower have to have filed a motion to request the strip down or the cram down?
Yeah, unfortunately, it's a little hard to answer that only because the bankruptcy rules do not have absolutely clear procedures on this, although that is likely to be changing in the next 3 years. But right now, I'd say yes. One thing you want to do is to go on the PACER system and look at the court file, and ideally, the best scenario would be that there will be an order entered at the end of the case. Now some courts, so some judges will enter an order, or it might be part of the confirmation order, and it basically says that that lien that is being stripped off is void or released upon, it's usually like a conditional order, upon the completion of the plan or the entry of a discharge at the end of the case. And so that conditional order might be enough if the debtor actually does complete the condition. I think sort of the better procedure, and one that hopefully you would find, is that at the end of the case, the consumer's attorney would actually ask the court for an order that makes very clear that the lien has been released or discharged. And ideally, I mean, that's the practice that I would use, and that order would be not only entered by the court, but would also be recorded at the land records to make absolutely clear that the lien has been released. Without something like that, it becomes a lot more ambiguous, and I don't know, I suppose one thing might be to contact, the consumer's attorney. They may or may not be responsive. But the other thing to remember is that particularly with these, there have been some exceptions to this, but the majority view, and I think the right view, is that the lien in that strip-off situation is not really eliminated or voided or released until the plan is completed. So if you have a consumer who's saying, yeah, I did this, and they never completed their case, well, that lien's still in effect. It would not have been voided.
Okay. And I think the other one actually, oh, here's another one now. There's one that's an announcement, essentially, that in Syracuse, there's been a loss mitigation program that started in the Northern District of New York in Syracuse, starting July 1st. I have no idea. I've not heard from the folks in that area how that's going or how well that's working, but I don't know, John, if you happen to.
Oh, that's good. I think I hadn't really heard about that. That's great news. I assume it's probably modeled after the one that was started by Judge Morris in Poughkeepsie, and it's in the Southern District and the Eastern Division. So, so if anyone, if anyone is interested in that, certainly contact me. I know some of the attorneys who have been in the Southern Division working on the loss mitigation program there, and there's been a lot of experience that's been developed under that program. But that would be good news. And certainly where there is a formal loss mitigation program, it does make it, it makes it a lot easier, I think, for some of these rules that or the guidelines that I just mentioned that may or may not be ignored. It makes it a lot easier to sort of put some fire to the feet of the servicers when you're in a formal loss mitigation program. So that's good news for Syracuse.
Yes. So the last question I think we have is why isn't the Fannie Mae rule regarding the need to release the mortgage from bankruptcy, the case or plan, unconstitutional or not enforceable? Has it ever been challenged?
Yeah, just to be clear, it's Freddie that has that provision, not Fannie. I think I initially misspoke and then tried to correct myself. So it is Freddie Mac who has that. It's real. I think it's actually a sort of a remnant of a policy that they have had for many years. I've tried to get them to change it. It's just part of their unfortunate agency mentality that their sense is that If the consumer gets this advantage of getting a modification, that they ought to the bankruptcy should end. Challenges to it, I suppose, that provision that I mentioned, the only hook that I see is that one that I mentioned about Section 525, which deals with discrimination by governmental units. And I think the problem with that is that, well, at least before they were taken over by the conservator, the FHFA, the case law seemed to be pretty clear that they're not governmental units for a lot of purposes, and I think that would apply for the bankruptcy code as well. Whether there are now arguments that because they have been taken over by the conservator that they are a governmental unit, I think there may be some arguments there. I know some in other parts of the country have been litigating the issue of whether there's state action for due process purposes in non-judicial foreclosure states. I think most of those cases have been failing, although I did hear that there was a recent case which was successful. And there's a law review article from Florence Reisman, someone who's been in the legal services community for many years, has written an article about why she thinks Fannie and Freddie are now state actors for due process purposes. So you might want to, if you're thinking about a challenge or think to that rule or whatever, you probably want to read that article. But I think, unless someone figures out a good way to deal with it, that is what we're sort of stuck with Freddie Mac anyway. Is there anything else, Becky? Hello, Becky.
It appears we just might have lost audio. Becky, are you there?
Okay.
Oh, yes, there we are. Looks like we're back.
Okay.
Sorry.
Okay. Is there anything else, Becky? Yeah.
Nope, that would be it. Just a general thank you. Perfect level of discourse. So thank you very much, John.
Okay, great. I was happy to do it, and thanks very much.
All right, great. To all the participants, thank you for the patience with the little glitches, and I thank you again, John. This was fantastic and very helpful and informational. Thank you.